May it please the court. My name is Campbell Collins, and along with my co-counsel Gabriella Lovins, I represent the petitioner, Roxanne Torres. When Ms. Torres was repeatedly shot by police officers, she was seized in a Fourth Amendment sense, both based on common law and this court's precedents. I will address the relevant common law, and my partner will address this court's prior cases. Would the court like a brief statement of the facts?
Yes, please.
On July 15, 2014, petitioner Roxanne Torres parked in the lot of an apartment complex. She was approached by the respondents, two police officers who were not in uniform. They were there to arrest a woman who had no relation to Ms. Torres. As they approached the parking lot, Ms. Torres, who had used methamphetamine, ran to her car. She only saw people in dark clothing holding guns and assumed she was being carjacked. At no time before she was taken into custody did she understand that they were police. She accelerated, and both officers fired at her repeatedly. Together, 13 shots were fired at the petitioner. Many hit her car, and 2 hit her in the back, temporarily paralyzing her left arm and injuring her so severely that she had to be airlifted to a hospital. The lower courts did not consider whether the force was excessive because they found that no seizure had occurred, because Ms. Torres sought medical attention rather than submit to the people whom she believed were carjackers. This court should overturn that decision based on founding-era common law and this court's own precedent. The question presented in this case is whether officers commit a physical force seizure, even if the suspect does not submit. Based on common law, they do, for 2 reasons. First, the relevant common law defines a seizure as any application of force, regardless of whether it succeeds in subduing the suspect. Second, courts cannot limit the protection of the Fourth Amendment to less than its protection at the founding. First, submission didn't matter. Based on founding-era common law, any application of physical force with intent to restrain was a seizure. The word seizure itself didn't imply submission at the time of the founding, and it was used in this sense into the Farmers and Planters of Maryland, where the writers wrote, "Seize it and carry it away with them." The word seize in and of itself didn't imply that the goods were taken into custody or under control. When a person is seized, that means that they don't need to submit for a physical force seizure to occur.
So, counsel,
And there's
what was a common law arrest?
Well, Your Honor, a common law arrest was any instance, generally when a bailiff was trying to detain someone who hadn't paid their taxes, when someone applied physical force to someone else with intent to restrain. And that force was a seizure, regardless of what the arrestee did afterwards. In a common law sense, a seizure was an arrest, and vice versa. They were used interchangeably. In the landmark 1765 case in Tick v. Carrington, the court alternated the use of the word seizure and the word arrest. And the Massachusetts Declaration of Rights equated searches in suspected places, arrests of persons, and seizures of property. And that's important because, again, just touching a suspect was an arrest, and therefore a seizure during the founding era.
So you're saying just touching is sufficient?
Yes, Your Honor.
Brushing my fingers across is sufficient?
Yes, Your Honor. In fact, the English Common Law Court held in Genner v. Sparks, a 1704 case, that if the bailiff had but touched the defendant, even with the end of his finger, it had been a seizure, with no reference to submission afterwards. And this is consistent with the original aim of the Fourth Amendment, which was to protect citizens against the villainy of writs of assistance or general search warrants, which, according to the court in Henry v. United States, a 1959 case, perpetuated the oppressive practice of allowing the police to arrest and search on suspicion. These warrants violated personal security, and the utmost violation of this security is violating the sanctity of the person, as held in Terry v. Ohio. And that's what physical force seizures do, regardless of whether the person submits.
So, Counselor, how should the original public meaning of the Fourth Amendment affect this case?
Well, Your Honor, in the case Wilson v. Arkansas, this court has addressed exactly that, holding that in evaluating the scope of the right of the Fourth Amendment, we have looked to traditional protections against unreasonable searches and seizures afforded by the common law at the time of the founding. And these traditional protections clearly included physical force seizures without submission. That's what Genner v. Sparks was all about. And case law supports looking back to this original definition. In United States v. Southeastern Underwriters Association, this court held that the court generally doesn't construe words used in the Constitution so as to give them a meaning more narrow than one which they had in the common parlance of the times in which the Constitution was written. And when the Constitution was written, a seizure meant force with intent to restrain.
So does this mean, Counselor, that you are encouraging us to construe the word more broadly?
No, Your Honor. We are going back to the original sense as the word seizure was used when the Fourth Amendment was written and applying that to today's case. And based on that definition, Ms. Torres was seized. And this is not just a one-time occurrence. This court has consistently based Fourth Amendment decisions on common law, such as in the case Carpenter v. United States, where the court held that it must base decisions on founding-era understandings when evaluating surveillance technology in relation to the Fourth Amendment. Or in the case United States v. Jones, when the court found that this court has interpreted seizures based on common law trespass and had done so for 2 centuries after the founding, and that the court has only recently strayed from this view, not entirely to the Jones court's satisfaction. Nowhere does this court state that founding-era definitions must be excluded from the scope of the Fourth Amendment. On the contrary, this court in Byrd v. United States held that modern Fourth Amendment tests supplement rather than displace the common law definition of a seizure. Thus, any case law since the founding can only increase the protections that were included under the amendment in its original sense. In conclusion, because common law defines physical force without submission as a seizure, and because this court must not make Fourth Amendment protections more narrow than they were at the framing and the founding, Ms. Torres was seized, and the lower court's decision should be reversed.
May it please the court. My name is Gabriella Lovins, and I too represent the petitioner, Roxanne Torres. Not only does common law support Ms. Torres, but so does this court's own precedent, for 3 reasons. First, the shots fall under the definition of a physical force seizure. Second, the shots were fired with intent to restrain. And third, limiting the definition removes many protections intended by the framers. First, the court has previously followed common law definitions of seizure in California v. Hodari D. The Hodari court held that a seizure requires either physical force or, where that is absent, submission to the assertion of authority. They elaborated more on what they meant by physical force, saying, to constitute an arrest, the quintessential seizure of the person under our Fourth Amendment jurisprudence, the mere grasping or application of physical force with lawful authority, whether or not it succeeded in subduing the arrestee, was sufficient. The Hodari court defined two types of seizures, physical force and show of authority. Show of authority seizures happened when an officer told the suspect to stop, and the suspect did stop and submitted to the officer. A physical force seizure happens when an officer applies force to the suspect with the intent to restrain. The action...
Let me interrupt you. Does the Hodari D court hold that the Fourth Amendment encompassed the common law definition of arrest?
Absolutely. They agree that it is a seizure if you apply physical force to the suspect, whether or not they submit themselves. The actions of the suspect are not relevant to whether or not a seizure happened. Now, this was also upheld in Florida v. Bostick when they once again agreed with common law by saying only when the officer, by means of physical force or show of authority, has in some way restrained the liberty of a citizen, may we conclude that a seizure has occurred. This case referenced Hodari D many times in coming to their decision, so it is clear that they are referring to the physical force and show of authority that Hodari D referenced when they used the words physical force and show of authority. Now this leads me to my second point. The test for a seizure laid out in Brower v. County of Inyo corresponds with the Hodari D definition. The Brower court held that a seizure occurs when there is a governmental termination of freedom of movement through means intentionally applied. This case was dealing with whether a seizure can happen unintentionally, not whether one can happen without the submission of the suspect. However, the governmental termination of freedom they mentioned does not have to result in submission. The respondents met the Brower standard when they applied intentional force meant to restrain Ms. Torres through bullets to her back.
So, Counselor, at what point does a police officer effect a seizure for the purposes of the Fourth Amendment?
Well, Your Honor, they effect the seizure when they apply physical force with intent to restrain, which can be grabbing someone or even touching them, as common law stated. Now, it may seem as if the touch has to be the officer's hand, but we also are given clarity on that through Brower. Brower said it was enough that Brower was meant to be stopped by the physical obstacle of the roadblock. In our case, it was enough that Ms. Torres was meant to be stopped by the bullets in her back.
And was the police officer shooting of Torres, was it reasonable?
No, Your Honor, it was not reasonable. The officers were not there to arrest Ms. Torres, and while they claimed they began shooting because they were worried she would hit them, the bullet trajectory analysis shows they were not actually standing in front of the car when they began firing. Their shots were definitely unreasonable. However, the question presented today is not whether or not the shooting was reasonable, it's whether or not a seizure occurred. And, Your Honor, we say that it did occur, based on common law and this court's precedent. Now, this brings me to my third point, which is why this is all important. Limiting the definition of seizure has unintended consequences that violate the rights protected by the Fourth Amendment. The Fourth Amendment was designed to protect the personal security of the people against government overreach. United States v. Martinez-Fuerte said, "The Fourth Amendment imposes limits on search and seizure powers in order to prevent arbitrary and oppressive interference by enforcement officers with the privacy and personal security of individuals." If an officer can get away with shooting a person just because the person didn't submit to them, they have still violated the rights meant to be protected by the Fourth Amendment. The Fourth Amendment was written to limit the power of government officials who have the power to violate our rights. In conclusion, the respondents seized Ms. Torres in a Fourth Amendment sense when they shot her, based on both common law and this court's precedent. We pray that the court will reverse the decision made by the lower court and grant Ms. Torres' appeal.